way in which that fits into the topic that we are discussing this morning. So without further ado, I invite David Irvine, AO, to make his presentation.
Thank you, Nick, and good morning, ladies and gentlemen. I'm speaking today as a person who has, in the past, been entrusted with the responsibilities for protecting national security and the lives of our citizens, and I'm speaking, in a sense, as a practitioner of the security intelligence function, rather than as a theorist or a lawyer. And the first point I want to make is this. In the assertion and counter-assertion of recent debate about laws governing the security, intelligence and law enforcement agencies, too much commentary, in my view, has neglected to acknowledge that the security and safety of citizens living within our community is just as much a human right as the other civil liberties of individual citizens. And you have to ask yourself, is there a point at which one has to be sacrificed in favour of the other? Or are they both, as I believe they should be, complementary elements of an indivisible whole? I agree with Justice Robert Marsden Hope when he said in one of his reports on the intelligence security business 30-odd years ago, he said, in the final analysis, public safety and individual liberty sustain each other. And for me, in a sense, the question is not so much how we balance freedom and security, but how we integrate these two fundamentally important concepts into the way in which we govern and the way in which we protect ourselves. Now, it stands to reason that if democratic governments are to fulfil their obligations to the community, the obligation of protecting the community, they need to have organisations and laws to enable them to do that, to enable them to anticipate and prevent threats. This predictive and preventative function of the national security intelligence is actually different, in my view, in nature, to the evidence-based prosecutorial function that operates after a contravention of the law has allegedly occurred. And the issue is further complicated, particularly public discussion about the issue, by the need for a security intelligence agency to operate mostly in secret, to protect both the subject of its investigations and its sources and methods. And as a result, of course, claims are often made that secret intelligence is of no value, and that secret agencies are a menace to our liberties. In the words of one very notable British commentator, that is quite wrong. We cannot do without secret intelligence to defend ourselves against enemies who themselves are operating in secret. So are Australia's lawful security intelligence mechanisms a menace to our civil liberties? Some aspects of intelligence legislation do indeed butt up against the purist view that civil liberties are untrammelled and cannot be derogated and so on, and certainly not by the so-called tyranny of the majority. I'm mindful of former South Australian Chief Justice Sir John Bray's acknowledgement that while the liberty of the individual and the right to privacy were values to be protected and not to be interfered with except for good cause, society was nevertheless entitled to use its power over the individual to prevent that individual causing harm to others. Community life would otherwise be impossible. And that is a principle which certainly operates when you're talking about things such as the prevention of terrorism within our midst. Here in Australia, we've addressed this issue of integrating national security, community protection and civil freedoms by developing what I think is actually a uniquely Australian system of laws and accountability mechanisms that provide a robust foundation to protect our citizens against unreasonable or disproportionate violation of civil liberties by organisations such as ASIO. The system involves very precise laws stipulating what the security agency can and cannot do. It involves in fact, very complicated accountability mechanisms and so on. The laws provide for strict and detailed operating mechanisms, guidelines set down by the Attorney General, and these are publicly available. The system provides for the concepts of necessity and proportionality in intrusive actions undertaken by the security agency. And importantly, it provides that where an ASIO assessment or activity that leads to a prejudicial outcome for an individual, and also the executive actions which were informed by those assessments, those decisions and assessments can be contested and reviewed within the Australian judicial system, including the Administrative Appeals Tribunal. And I've spent a lot of time working on issues with ASIO in the Administrative Appeals Tribunal. Secondly, our system provides for a variety of oversight mechanisms: a joint parliamentary committee on intelligence and security, appearances before Senate estimates, which if you've never done it is an excruciating pleasure not to be missed, and then, but most importantly, the creation some 30 years ago of what is essentially a standing royal commission, the Office of the Inspector of Intelligence and Security, which on a daily basis examines the activities of an organisation like ASIO to ensure that those activities are carried out legally, appropriately and with appropriate propriety. Now, as a practitioner, I'm satisfied that our system is an effective mechanism for working through and resolving the perceived tensions between the basic human right of citizens to be protected, for example against terrorism, and their rights to established civil liberties, including privacy. Nonetheless, because our national security legislation is so detailed on what isn't permitted, it's proved necessary from time to time to revise or modernise some laws, or even to introduce new elements of legislation to enable governments to deal with changes in what I call the national security and law enforcement operating environments. These environmental drivers, if you like, are essentially of two kinds. The first is the rapid development of technology, which requires legislation to be updated or modernised to enable us to continue to carry out the functions that we have of protecting the nation, not just from terrorism, but of course from serious crime, various other forms of politically motivated violence, cyber attack, espionage, and so on. And indeed, recent changes to much of ASIO's legislation in relation to surveillance, streamlining and modernising of the warrant process, the lawful interception of communications and so on, including the metadata issue, most of these have been necessary as a result of technological change. And indeed, the metadata legislation seeks essentially to preserve the status quo. And the second thing is that the threat environment can change too. And of course, clearly, the advent of terrorism and the way terrorist methodologies have evolved has forced governments to develop new powers, or to consider new powers, to deal with the constantly mutating terrorist threat. And so the powers that were given to ASIO since 9/11, for example, for the compulsory questioning of people, or even the questioning and detention of people for the purpose of obtaining intelligence about terrorism, were in a sense new powers for ASIO. Now, unfortunately, ASIO has never had to use the questioning and detention powers, and I hope it never will. But it has used the questioning powers on a score of occasions and to very good effect that protects the community. And secondly, the recent legislation to apply the concept of legal immunity to ASIO are clearly new powers, although they certainly attracted the headlines, another ASIO grab for power. But in fact, the concept of immunities for the authorities in, for example, controlled operations for the AFP is not a new concept in Australian law. The AFP has had similar powers for some years. The government has also introduced other forms of legislation more related to the prosecution of potential terrorists in Australia, less associated with ASIO. But more recently, of course, the government has given notice that it is considering the withdrawal of Australian citizenship from dual nationals who engage in terrorism at home or overseas. Now, the polls suggest that public opinion is running very strongly in favour of such a move, because any removal of citizenship could prevent persons overseas from returning to Australia to pose a direct threat on our soil, or would enable the deportation of such persons from Australia. The process for determining withdrawals of citizenship, whether it be on the decision of ministers with judicial review, or only as a result of a criminal court process, is, as you know, currently the subject of debate. But as a practitioner, in talking about all of this legislation, may I issue a plea for people to keep an eye on the practical implications of some of the things that they're suggesting. It's too easy, for example, to assuage people's concerns about the intrusive powers of ASIO simply by adding more oversight or bureaucratic approval mechanisms every time we adjust the operating legislation, as if additional bureaucracy and increased cost is going to provide a more effective and greater level of assurance to the public than those already in place and proven over decades. So, if you want to beef up the accountability process, then my suggestion is give more resources to the Office of the Inspector General of Intelligence and Security to enable that office to continue its practice of carefully monitoring on and reporting to the government and the Parliament on the deeds and, if necessary, the misdeeds of the community so that they can be remedied. Summary conclusions. Public polling consistently shows that Australians are generally, and in my view rightfully, concerned about the threat of terrorism. They expect governments to protect their security and safety and have shown a willingness to surrender elements of their civil liberties in order to obtain that protection, provided that they can be confident the agencies will only do as much as is necessary for their protection and no more, the principles of necessity and proportionality, and that the agencies are accountable and properly oversighted. And my view is, as you will understand from what I've said, that they are. Let us debate and justify every new piece of legislation, but let's not reinvent the wheel every time the laws governing the security agencies need to be modernised or refined. We should accept the fact that the unique Australian system is working and that the control and oversight mechanisms are indeed effective. One more point that I think we do need to consider. A security intelligence organisation like ASIO, operating in a liberal democracy under the rule of law, can only be effective if it has the support of the Australian people. Governments and the agencies themselves, I believe, in the future, will increasingly be required to assist their populations, their politicians, their press, and dare I say it, the legal fraternity, to understand the nature of modern intelligence work and the system and checks and balances that operate with it. One final thought. Please spare a thought for the officers of ASIO. Unlike those who can snipe from one side or the other of the virtuous human rights national security divide, every day they have consciously to make decisions that do indeed integrate respect for civil liberties and human rights with the imperative to collect and assess intelligence that enables governments to meet their obligations, the protection of the community. Their successes are often unremarked, their failures invariably a subject of public castigation, but believe me, you need them. Thank you.